The 1972 Supreme Court case Wisconsin v. Yoder was a dispute between three Amish families and the state of Wisconsin. The conflict first arose when three separate families in the New Glarus School District had their children stop attending New Glarus High School in Wisconsin due to their very strong religious beliefs. According to Amish standards, any education past the 8th grade was deemed unnecessary for their simplistic way of life, but also endangering to them and their salvation. The parents tried to appeal for an exemption due to their religious beliefs, and the families also believed that the knowledge their kids would learn at home would be more beneficial than anything they could be taught in school. Since the state of Wisconsin had a law at the time stating that anyone under 16 was still required to attend school, and since the families had pulled their kids out before they were 16, they had broken the law. New Glarus High School filed a case against the families, which ended up going to trial in the Greene County Court, where they were convicted and each fined $5. The convictions were held up in both a trial court and a circuit court, but once it reached the Wisconsin Supreme Court, they found that applying the law to the Amish actually violated the First Amendment's free exercise of religion clause. The families were at a disadvantage from the beginning, since their religion did not believe in settling disputes in court, but rather just turning a blind eye. But because of how strongly they felt, one of the fathers, Jonas Yoder, decided he would argue the case. The case eventually reached the floor of the Supreme Court of the United States and was argued in front of them on December 8th of 1971. The case was argued in front of Chief Justice Warren Burger and Associate Justices William Douglas, William Brennan Jr., Potter Stewart, Byron White, Thurgood Marshall, Harry Blackmun, Lewis Powell Jr., and William Rehnquist. The court ruled in favor of Jonas Yoder 7-0, while Justices Lewis Powell Jr. and William Rehnquist both decided to not take part in the vote. The United States Supreme Court held that 1. States cannot force individuals to attend school when it infringes on their First Amendment right. In this case, the state of Wisconsin interfered with the practice of a legitimate religious belief. 2. Not all beliefs rise to the demands of the religious clause of the First Amendment. There needs to be evidence of true and objective religious practices instead of an individual making his or her standards on such matters. The Amish way of life is one of deep religious convictions that stems away from the Bible. 3. With respect to the state of Wisconsin's argument that additional modern education beyond 8th grade is necessary to prepare citizens to participate effectively and productively in America's political system, the court disagreed. It argued that the state provided no evidence showing any great benefit to having 2 extra years in the public schools. Furthermore, the court contended that the Amish community was a very successful social unit in American society, a self-sufficient, law-abiding member of society which paid all of the required taxes and rejected any type of public welfare. 4. The court found no evidence that by leaving the Amish community without 2 additional years of schooling, young Amish children would become burdens on society. To the contrary, the court argued that they had good vocational background to rely upon. Justice William Douglas filed a partial dissent but still voted with the court. Justice Potter Stewart and William Brennan Jr. filed a concurring opinion due to the Amish children sharing the same religious objections to school attendance as their parents. Justices Byron White, William Brennan Jr., and Potter Stewart also filed a concurring opinion, which stated that it would be a completely different case if the parents forbade their children attending any school at any time and from complying in any way with the state's educational standards. This Supreme Court ruling is still in effect today and is cited as a basis for allowing people to be educated outside of the traditional private or public school setting, such as with homeschooling. The implications of the case for the Amish were characterized as all states must grant the Old Order Amish the right to establish their own schools if they ever choose to, or to withdraw from public institutions after completing 8th grade. In some communities, Amish parents have continued to send their children to public elementary schools even after the ruling of Wisconsin v. Yoder. In most places, tensions eased considerably after the Supreme Court ruling, although certain difficulties remained for those Amish living in the state of Nebraska.